before we got our Supreme Court rejection of the case to invalidate the state DOMA, we had the Vazquez case affirm that sexual orientation could be considered under the meretricious relationship doctrine for couples who were not married and yet who were dealing with a dissolution or a death, that the court could step in and apply principles of fairness to determine who got what in terms of property and distribution. We had a man named Vazquez who has been 30 years with another man who died without leaving a will, and his family had come in wanting to take the house and to kick out the other guy because he was, as far as they were concerned, just a caretaker. They didn't want to deal with the fact that he was his partner, lover, sexual spouse, whatever. And he became represented by a law firm that took on his case and pro bono and really helped him through it. The appellate court said because we had a DOMA law that meretricious relationship was enough like a marriage that the court would not be allowed to apply it to same-sex couples, and therefore they couldn't find for him that he had an entitlement to the property. And then the Supreme Court of the state did find for him and declared by their majority that meretricious relationship could be applied without regard to sexual orientation. And that was a great victory at the time. And it ended up in he got to keep the house. Although the way he got to keep the house was that the law firm basically negotiated with the family a payment of some tens of thousands of dollars now, and that after this man's demise that they can have the house. Otherwise they would have appealed it more and more, just kept going to try to get him out of there. So anyway, the courts have been important here, and some judges, like Judge Downing in King County, wrote a wonderful brief on the Defense of Marriage Act and its unconstitutionality. That was that in a case from Thurston County where the occasion for the state Supreme Court's decision. We would have been the second state to have marriage after Massachusetts if our court had ruled 5-4 the other way, that Defense of Marriage Act was unconstitutional because you can't amend the Constitution of the state of Washington by popular vote. You first get a 2/3 vote of the House and Senate, followed by a popular vote. So that means that if you can keep 1/3 plus 1 on your side of an issue, you can prevent a constitutional amendment from being passed against you. So we thought we could do that. 1/3 plus 1 in either the House or the Senate. So, but we were disappointed. It took 2 years for them to tell us no. And then it was by the slimmest of margins and by the most ridiculous reasons. Well, heterosexuals wouldn't have babies if they just, the same-sex couples were allowed to marry.